Privacy Proficient.
Did you know that privacy training is mandatory under the CCPA? That's what we're going to be talking about in this edition of Privacy Awareness by Privacy Proficient. Under several sections of the CCPA and the regulations, privacy training is called out in one way or another. We're going to go through each one of them. But the upshot is that basically all of the individuals responsible for compliance with the CCPA need to be trained on all the requirements in the CCPA and all the requirements of the regulations and how to direct consumers to exercise their rights under the CCPA and the regulations. So let's take a deeper dive. Let's first of all take a look at one of the more narrow provisions for larger companies under the regulations 999.317. It talks about companies that collect personal information, sell or share personal information of over 4 million consumers. And the requirement there is that they have a training policy. So they specifically talk about training to ensure all individuals responsible for handling consumer requests or the business compliance with the CCPA or the requirements in the regulations for both. So, and this is annually. So it's 4 million consumers annually. So you have to kind of project over the next year how many consumers you're going to have. You may think, well, we're a small business. This doesn't apply to this. We don't have to have a training policy. Well, that's fair. Maybe you don't have the personal information of 4 million consumers. So maybe not a formal training policy is required. But let's keep going. Under Regulation 999-330, it talks specifically about minors and opting out of sale of personal information. Here, if you're targeting children, or even if children are using your products and there are requests to opt out or back in, you have to train people to deal with those requests. And specifically, they're talking about the toll-free number. People who are staffed to answer the toll-free number need to be trained personnel. Those who might do video conferences with the children or their parents or guardians need to be trained. And those persons who do in-person interaction in this regard have to be trained. So the focus here is on children, making sure that the people who are dealing with the requests with respect to children are trained, which is understandable. And what do they have to be trained in? Well, methods reasonably calculated to verify that the parental relationship exists, and situations regarding opting out of sales of personal information. And they're responsible for compliance, all requirements. So special focus on children. So first two, large companies, 4 million consumers, now special focus on children. But let's keep going. Under the actual statute, Section 135, so it's 1798-135, it calls out that a business is required to comply with businesses that are required to comply with Section 120, which are those who sell personal information. So now we're talking about broadly any business who sells personal information. And by the way, sale, the term sell is extremely broad. I mean, you don't even have to give someone personal information. You can just make it available. You put a file on a share, and the people don't even, the other company or whoever it is you would think you're disclosing it to, doesn't even access it. It's just available. That's within a sale if it's done for consideration. Consideration is very broad. Doesn't have to be money. Anything of value. Say if a contract with a company, it's very extremely broad. Let's put it that way. And who do you have to train? All individuals responsible for handling either consumer inquiries in the privacy practice or business compliance. The business is compliance, it's possessive, so it's talking about the compliance of the business. So this is very broad, a broad set of people. We're going to talk a little bit more about this, but it's going to be hard to think of someone in your company that's not touched by this, because of the nature of the scope of the definition of personal information. It's much broader than under previous laws. Remember, under federal laws in the United States, it's sectoral, so you deal with just maybe financial personal information under the Gramm-Leach-Bliley law or canned spam marketing information, etc. Here, you're dealing with a broad definition. So it's very broad. It's extremely broad. So it's going to touch a lot of the people who are in your company, maybe all of them. But what do they have to be informed about? All the requirements of Section 120, the opt-out section, opt-out of sales, and of this section it says. So it's basically, they're focusing here on opt-out and how to direct consumers to exercise their rights on opt-out. Notice also, if you think about the business who sell, even if you don't, if you hire a cloud computing company or a web services company and you make available something that might be considered personal information to another business or a third party, this is very broad. It's subtle, but remember, a service provider can be another business. It's not mutually exclusive. A service provider can also be an entity that is a business in and of itself. And a third part, same thing with a third party. A third party by definition is a negative definition, the way they defined it. If you're not an antelope or a platypus, then you're a cow, is the way they define third party. If you're not these two things, one of them is a business and the other one is a certified entity. They don't give a name to it. It's kind of like a service provider, but it's not. So you can be a service provider and a third party. So what this means is that selling can be a lot of things, even to associate companies that you're dealing with to help you do things. So this pulls in the scope of those businesses that are affected by this requirement to train regarding opt-out of sales. Let's keep going. Section 130, A6, talks about in order to comply with 5 different sections having to do with requests for categories of data, specific pieces of data, requests to delete data, obligations regarding the business that collects data, obligations of businesses that sell data, and non-discrimination. So for those 5 sections, in order to comply with them, you have to ensure that all people responsible for handling consumer inquiries about the privacy practices or business compliance, again, the business's compliance, are informed of all the requirements of those sections and how to direct consumers to exercise their rights. So there again, you've got this very broad requirement. The focus is on these sorts of requests. I think that's the sort of focus. But it could involve people like your operations personnel, your financial folks, because non-discrimination involves valuation of personal information, and things like the offers that you make, selling data. So very broad, very broad. Let's keep going because there's more. But before we get to the next section, let's take a sort of a step back and think about all the potential people that might be affected in your organization. I'm going to assert that it might be true that there is no one in your organization that is not immune, or that is immune to this training requirement. Most employees are going to touch in some way, are going to be involved with compliance. And here's some examples. So your executives who are accountable for compliance requirements, managers who oversee compliance requirements, projects and operations, HR who are responsible for training and awareness, finance for non-discrimination. These are just examples, but the legal has to write the privacy policy, product developers have to implement privacy by design, website developers have to put the do not sell button and then implement that. Testers have to test all this stuff. Database developers have to deal with data retention and deletion and requests. The operations folks have to handle requests. Customer service, retail. Somebody could walk into one of your stores, if you have retail stores, and say, give me my data or delete my data. And certainly your sales and marketing and advertising people have to deal with do not sell. So the overall conclusion, I think that's happening here, the overarching theme is that the sectoral approach in the United States to privacy is outmoded. So if you're not aware of it, the privacy laws in the United States have been much formed around sectors, financial sector or the marketing sector or healthcare sector. You got HIPAA that applies to covered entities. And so it's very compartmentalized. This is the CCPA is a fundamentally different approach. Imagine that you are living in a village. You're living in a village and everything's going along fine. And then one day the village is flooded, right? So now you got water everywhere. And everybody has to learn either to swim or to use a boat or both. You're going to have to deal with this water. Everybody wants to stay in the village, but the water's everywhere. The personal information is everywhere in your company. And everybody's going to be touching it in some way or another because personal information is defined so broadly. So your village just got flooded, which means your employees on every aspect of your company are probably going to have to be trained. And according to the CCPA, what do they have to be trained in? All the requirements of both the statute and the regulations. Is this a good thing? Yeah, because it protects your consumers. It's very customer centric. And in the long run, it's going to be very good for your business because if you can step up to do this, your customers are going to trust you more and give you more business. So it seems like it's a lot, and it is a lot, but it's a good thing. Let's take a step back and look at the GDPR and then the coming federal legislation for perspective on this. The GDPR, if you think, well, we trained people for the GDPR and that was enough. They had some references to training, but they kept it at a very high level. They required the board, now that's a government entity, the European Data Protection Board, to promote training programs. And if you have a data protection officer in your company, that person was responsible for some training effort. So very high level requirements. CCPA is much different. It goes right into detail, very detailed requirements, but very broad requirements. So if you've covered this for the GDPR, you're not nearly covered for the CCPA. You've got to implement much more thorough training for the CCPA. Let's take a look at the COPRA, which is one of the proposed federal laws. So there's a lot of talk about privacy law that might be implemented by Congress nationally. And there's various debates about them to sort of either preempt California's law or the other laws or not preempt, let the states do whatever. But let's take a look specifically with the training. Who is required to be trained under the proposed COPRA law? Well, it's all employees with access to covered data. Here's the thing. The personal information under COPRA has a broad definition also. It's like the village got flooded. All the people in the village have to learn to swim or use a boat. So it takes the same sort of broad brush approach, but it doesn't get into the details of specifying certain people have to learn certain things. But it talks about all employees with access. That's going to be a lot of people, and probably arguably everybody in the company is going to have access to some personal information because it's going to be broadly defined. And what do they have to learn? Here again, very broad, to protect individual privacy, safeguard covered data, and protect individual privacy. So whether or not the California law is preempted, it looks like this is inevitable. You're going to have a broad training program for all of your employees. Get used to your town or your village being flooded with water. Get used to training people to swim and to use boats. Get used to it. And if you don't believe me, let's take a look at another provision of the CCPA. This one is specifically entitled training. So it's section 317, and this is even broader than the previous sections. Who needs to be trained? All individuals responsible for handling consumer inquiries about the business privacy practices or the business compliance with the CCPA or the regulations. So here again, very broad. A lot of employees are responsible: customer service, testers, website developers, app developers, HR, legal, financial, marketing, sales. In different ways, they are doing different things to be compliant with this law because personal information is everywhere in the company. And by the way, there is an employee exemption. So you might say, well, within the company, the personal information we don't have to worry about for another year. Yes and no. I mean, it's coming. The exemption is scheduled to sunset in a year by 2021. The other thing is, it's not a complete exemption because it's only exemption for people within their roles. If employees acting outside of the role of the employee, then the personal information is covered even within the company. So if you allow your employees to do things like use their business machines to visit social networking sites or stores, buy things, or order food from restaurants and so forth for their personal use, then guess what? All that data that's going back and forth is covered. It's not exempt because that's not within their role as their employee. That's their personal business. And what do they have to be trained in? Again, all the requirements of the CCPA and the regulations. Now, I want you to take a look at something here. It says shall be informed, and the word informed is used in several different places. So you could hide, a company could say, well, it doesn't say trained, it says informed. So we'll put up a web page and we'll put up the requirements. And we've done it. We've check marked that requirement. We're okay. Well, if the Attorney General comes after you and there's a violation or a series of violations or a pattern of violations or a data breach, are you really going to hide behind the word informed and not train your employees? Because informed of all requirements of the regulation and the law is very broad. This is a complicated law, complicated regulations. There's a lot to it. There's arguably hundreds of little subtle requirements, and just putting up a website or sending an email out to everybody and say, boom, we did it, they're informed, I don't think that's going to cut it. You really have to train folks on what the requirements are, what their part is in it, and give them the overall picture so they can understand the gravity of this. There are some serious downsides to what might happen to not just an employee, but the whole company by one employee doing the wrong thing. So all people responsible for compliance, they need to be trained in all the requirements of the law and the regulations, the statute and the regulations, and how to direct customers to exercise their rights. So the takeaway, train all employees responsible for any aspect of compliance on all the requirements of the CCPA and regulations, especially around consumer requests, opt-outs, and where children are involved. And it's probably a good idea to create and maintain a privacy training policy. If you like this video, please subscribe to our channel and share it in your social media. Thank you, and we'll see you next time on Privacy Awareness by Privacy Proficient.
Privacy Proficient.